Welcome to this free immigration help channel. Today is July 7, 2023, and we are getting into the volume 133 of me answering your immigration related questions. As always, before beginning this video, I'm going to mention I am not an immigration attorney. This is not a legal advice. All the information provided in these videos on this channel are directly from official government sources like USCIS and of course the Department of State with their visa bulletin. So let's start with the very first comment. Looks like there are two from Shahlala745. So I'm going to start with this one. Looks like this is the first one. I had been refused of entry from a European country because I unintentionally had broken the Schengen visa rules. I had stay in country A, but I booked the hotel in country B that was 2 hours far from country A. Is a refusal of entry considered as a deportation or removal? Thank you for your time. And then the second comment is, because their ID, there is a question in form 260, which is DS260. Have you been deported or removal from any country? Now I am confused. Shahlala, thank you very much for asking the question and sharing your story. It's very interesting. I know I heard a few situations with the Schengen visa, similar situations to yours, because it's so confusing and people unintentionally breaking those rules, regulations that are there in European countries. But to answer your question, no, it is not considered a deportation or a removal. Deportation is where basically you are being reported. If you refuse the entry, it's not the same as a deportation, and it is not the same as removal. So in the DS260, you can say that no, you've never been deported or removed from any country. I don't remember if you ever had a refusal. I believe there was a question like this in there, but if there is, then you say yes, and then you explain the situation. If there isn't, then you don't need to worry about that. And this is of course part of becoming documentarily qualified process. This is on the video of documentarily qualified. What does it mean? So I'm gonna put my answer here, and we're gonna move on to the next common question from Shinuda Bekit 8701. Shinuda, thank you very much for being publicly subscribed. This is what this icon means. I really appreciate it. So Shinuda says, hello again. My friend is in removal process and he has a court in 2025. My question is, can he file I-485 or he's stuck with this court? Okay, so it's an interesting question. It really depends on what kind of status your friend is in. If he has a court, if he is in removal proceedings, then most likely he's not eligible to file I-485, because I-485 is for the adjustment of status. And in order to adjust the status and become a permanent resident, you actually need to maintain some kind of granted basically status, like for example granted asylum, granted refugee, or through a family reunification. So if he doesn't have any of that, which sounds like he doesn't, because if he did have it, he wouldn't be in the removal proceedings. So I think for your friend, I-485 is a little bit too far ahead for now. I'm not saying that there's nothing that can be done, but I think there's a few things beforehand that needs to happen in his or her immigration, in his immigration process. What I would definitely recommend though for your friend is to reach out, do some consultations with immigration attorneys, or at least find somebody who does pro bono, some immigration practitioners that offer cheaper services than immigration attorneys, but are still qualified to provide a legal immigration advice. Because since he's dealing with a court, I would definitely recommend doing this. Is it possible to go through the court yourself? Yes, but honestly, I wouldn't recommend, especially if there are considerations like filing I-485, which is way too early and really doesn't make sense in his situation. Okay, second question, can he apply for a work permit and how? Again, if he is in removal proceedings, I highly doubt that he's eligible for the employment authorization document. If he was, for example, pending asylum status or something along those lines, then, after a certain amount of time with a pending asylum status, you can apply for employment authorization document. But again, if you are in a pending asylum status, you wouldn't be in the removal proceedings. If he's in removal proceedings, then I don't think he has any eligibility for adjusting status or permanent work permit or anything along those lines. And then the third question, if he changes location to another state, can he apply online or any changes in his case? Thank you very much. You're very welcome, Shinuda. Thank you for asking all these questions. So it doesn't really matter. Changing state doesn't really have any impact on immigration process, because immigration law is federal, and really whichever state you're dealing with, at the end of the day, you're dealing with the federal law, the federal regulations that apply to you. The only thing that changes based on state are sometimes the service center. Again, depending on what kind of application you're applying for, what you're submitting really doesn't make a lot of difference. The only thing to keep in mind is if he does change the state, he has to update USCIS with the updated address if he currently has some kind of petition or application, which honestly doesn't sound like he has anything at the moment. So again, I would definitely highly recommend him reach out to some legal help, some immigration attorneys, or at least immigration practitioners. Okay, let me put the answer here, and we're going to move on to the next comment question from Sunrise GP3YM. Hi sir, now F1 filing action almost August 2017, and my brother filing action is February 2017, and portal is still closed. My question is, shall I send inquiry or wait till the end of July? Thank you for helping us. Okay, so let's take a look at the visa bulletin just to make sure we're looking at the same stuff. So that should be graph B, because we're looking at when the NVC portal is going to be open. So it is showing September 2017, and you said your brother is in February 2017. So technically your brother's NVC portal should be already open, and he should be able to have the access and basically ability to start his documentary qualification process. So it depends on when you have reached out to NVC last time. When was the last time you submitted the public inquiry form? If it was a couple of months since you submitted it, yes, I would definitely recommend reaching out again. But if you want, you might wait a few more days. We don't have to wait till the end of July. I'm thinking few more days. I think next week the new visa bulletin will be coming up, because usually the new visa bulletin comes out either the middle of the month or even the first half of the month most of the time. So we will see. The August 2023 visa bulletin should be coming out really soon. So if you want to wait just a little bit more, probably like till the end of next week max, we should be able to see what's happening, and if there were any updates, and then maybe with an updated information you can reach out to the but submit the public inquiry form basically. So I would recommend probably waiting, just so that you have the most updated information, and then submitting the public inquiry form. Okay, let me post the answer here, and we're gonna move on to the next comment from VCow5198. Hi, my boyfriend has been waiting for the political asylum interview for more than 2 years. He applied in December 2020. Then he applied for EAD in the next 6 months and got his EAD card in August 2021. His EAD is expiring and we need to renew the driver's license. So we applied for an EAD renewal application today, July 2023. I have US citizenship and wonder if I can help him to get a green card faster through a sponsor pathways overlapping with his pending asylum. Do you have any advice on this? Thanks. Thank you very much for your question. Absolutely. I mean, if you guys decide, whenever it comes to marriage, it's sacred, right? Obviously. So you wanna get married out of the right intentions, not dealing with this bureaucracy. But to answer your question, will it help with his documents? Yeah, absolutely. Because if you guys get married, you can petition for him, and I have a lot of information on this channel about so from the scratch, basically the whole process of family reunification. And since he is already here in the United States of America, you can just file the whole application package with the form I-130 and the application to basically adjust status for his permanent residency, and he doesn't need to leave the country. He can go through the whole process here. And because you're a US citizen and it's going to be your spouse, it's going to be immediate relative category, so there is no backlog on the immigrant visas. The immigrant visa is immediately available once the petition is approved, so it's going to be a pretty quick process. Still, it will probably take about year and a half you're looking at easily, because there are some steps that are involved, but it is obviously much easier, much faster than going through the asylum process. Asylum is much more complicated than family reunification. The only things that are most of the times annoying with family reunification are this medical examination that you have to go through, but which he will have to go through regardless. Once he gets his asylum approved, then he waits 1 year to apply for his permanent residence, and he will have to deal with this regardless. But again, there is no immigrant visa backlog that you guys will be dealing with, so it will be much faster compared to most other family reunification process. So if you guys decided that you're gonna spend the rest of your life together, everything's good, and you're gonna get married anyway, absolutely, if you get married, it will definitely big time help his immigration case. The only thing that you would need to keep in mind is, once you see that it is closer to the completion of the family reunification process, your I-130 petition, make sure to actually file the papers in order to withdraw the asylum application, so that it doesn't come up with a situation where you have one case that is pretty much ready, and his immigrant visa is available, and his asylum application is still pending. You definitely don't want to be in that situation, because it might cause some confusion. Okay, so let me put the answer here, and we're gonna move on to the next question from Anonymous 04 or 04. What if you are already in the United States? How is the process going to look like then? And that's for the form I-130. Anonymous, thank you very much for the question. I really appreciate it. I think I'm gonna make actually a separate video on that. Basically, it is practically exactly the same. The only thing that is different is that the interview itself will be, the beneficiary will be going through the interview here in the United States and in one of the field offices, and also you have an option to file the I-485 together with the I-130 initially as one application package. Everything else is for the most part exactly the same, but I will probably end up making a whole separate video just so that it is clear, just so that the steps are kind of clear, but expect the same stuff. Filling out the form I-130, submitting it online. Honestly, it really doesn't matter if you submit the full application package together with I-485 or you submit it separately, I-130 first, because again, it's going to be processed in that same order, the same way regardless. So you have to wait for the approval of I-130 by USCIS, and then dealing with the NVC and all the medical examination and the interview. It's pretty much exactly the same, so it really doesn't matter. But so let me post the answer right here, and we're gonna move on to the next comment. Actually, two comments. My son priority date October 2020. He's under F2A and he's documentarily qualified in January 2023. And then Nadine Parkinson says, "Good evening. Can you please tell me the date for the visa bulletin for August? I know that move up 3 weeks for permanent residence filing for under 21 child." Okay, so let's take a look. So we're looking at F2A. Priority date is 2020. Since he is already, your son is already documentarily qualified, we're going to be looking at the graph A instead of the graph B, which is showing final action dates, basically when is the immigrant visa is available, the immigrant visa itself, so the whole length of the backlog for the immigrant visa. So F2A right now is showing September 2020, and your son's priority date is October 2020. Okay, so sounds like your son is just 1 month away. So let's see when September September 8, 2020, and your son is October 2nd, 2020. So roughly 1 month more for the availability of the immigrant visa. We will see when the new visa bulletin comes out in the next, hopefully less than a week. We will see if there is any movement for F2A. Hopefully there will be, and hopefully the next visa bulletin will show October 2020, and your son's, priority date will become current. But everything is moving great because, he was already documentarily qualified in January 2023, and it's been more than 6 months now since he was documentarily qualified. So once the immigrant visa becomes available, once the priority date becomes current, the interview is right around the corner. Again, right around the corner. It might be somewhere around 4 to 6 months. It might be faster, it might be a little bit longer depending on where the U.S. Embassy is and how busy it is. But overall, it's pretty much at the completion. Just make sure to come back to this channel. I would really appreciate, Nadine, if you could come back to this channel and let us know when your son is scheduled the interview, because it's really nice to get the comments with the resolution. And trust me, it's a blessing to get the comments with questions, and hopefully my answers, some of my answers at least, are helpful, but it's also nice to hear the resolution. It really is great to read that everything is completed and everything is good to go. Okay, let's move on to the next question comment from Tina 7914. Thank you, Tina, for being publicly subscribed. I really appreciate it. Hello, thanks for the informative and professional videos. You're very welcome. Thank you for watching. I'm applying for a change of status from F2 to F1 online. Okay, so if I'm understanding correctly, from F2, you are referring to non-immigrant visas, student visas, F2 being the dependent of a student, and F1 being actual student. What documents do you recommend I include that are not specifically mentioned on USCIS document checklist? Example, do I upload a cover letter? Do I explain why I'm applying in the US instead of my home country? Do I upload documents to prove home ties? Thanks. Tina, thank you very much for your question. That's a really good question. I haven't had something like this. I haven't heard anyone changing from actual dependent to the student. Congratulations, now you're a student yourself. That's great. So the most important documents whenever it comes to stuff like this, of course, would be your, I think it's I-20, all the civis stuff that are associated with being enrolled in school, in some kind of education here in the United States. I don't think there will be any problems or any questions about why you're applying here in the United States, because it's easily explained. Why? Because they see themselves that you have been here on F2 status, which they have approved themselves, and you came here as a dependent of a student. Everything is good. So I don't think you need to worry about any of this. Of course, the cover letter, if you want to add some kind of explanation, it doesn't hurt. And, if there are some kind of unique situations, I always recommend submitting a cover letter. And in your case, it is a little bit unique because, you came as a dependent, so you didn't really have intentions to study in the United States first. But now you do have the intentions to study in the United States. So if you want to explain that, it's not gonna hurt for sure. Whenever it comes to the home ties, showing the documents that you have ties to the home and you're gonna return, you really don't need to provide any of this because you are already in the United States of America, and now you're switching from the dependent to the student. And honestly, if you had intent not to go back to the home country, there is really no point for you to change the status to the F1 because you're already here in the United States of America, and you could have just stayed and not went back. You doing the change of status actually shows your good intentions and maintaining the correct status because, and getting the education too. So I personally don't see any kind of red flags in the eyes of USCIS looking at this and saying, oh, this person is trying to stay in the United States and not go back. So I think you should be good. I don't think there's going to be any questions about you not returning home or why you're applying from the US and not from outside of the US. What I think you really need to concentrate on is the stuff from the school, all the school documents, the enrollment letter, and so far so forth. And if you want to provide a cover letter with some brief explanation, it's not gonna hurt as well. Okay, so Tina, thank you very much for the question. Let me post the answer here, and we're gonna move on to the next common question from user EC3. Sorry, now YouTube is showing me handles instead of names. I don't know why they did it. So the user says, please, what about the children of the family which has the F3? Thank you very much for the question. So it's the same thing for all the family preference categories, whether you're F1, F2A, F2B, F3, F4, it doesn't really matter. CSPA applies the same for all 4 family preference categories. It applies a little bit different to the immediate relative category, and then for family preference category, again, whether it's F1 or F4 or F3, like in your situation, it's the same. And the difference is that for immediate relative category, the age of the child actually freezes when the application is approved, when the application is submitted and accepted by USCIS, compared to the family preference categories, where you can subtract the amount of time that the application was pending with USCIS. And that's really it. So the age doesn't freeze, unfortunately. So thank you for your question. And if you have any follow-up questions, don't hesitate to ask them. Just make sure you don't respond to my question within my comment within your comment, because YouTube does not send me the notifications for those. Okay, moving further to Article 3875. Article, thank you for another question. Really appreciate it. Another comment. Hello, bro. First of all, I would like to thank God for giving you the strength to help us in our immigration journey. Thank you. God is good, so He's giving me a lot of strength. Finally, my older daughter's case has been documentarily qualified after I followed up with a public inquiry. My family case is documentarily qualified. Fantastic. That's fantastic news. You have been really helpful. Trust me, you are the best. May the good Lord give you more strength and patience to help all. Thanks, bro. Odegal, thank you very much for your kind comment. Appreciate it. And I am really, really happy for you and your family. And I am really grateful to God that He took care of your situation. It's really great to hear comments like this. This is exactly what I'm referring to. It's awesome to receive, the questions and being able to answer them, but it is, obviously very nice to read resolution comments like this, knowing that everything was resolved. So article, really appreciate the update, and that's awesome. Really happy for you and your family. Okay, let's move on to the next question comment from CS Bonito. Thank you for your answer. Just one thing. You say that the cover letter and statement are the same thing, but one you are filing out the application, there is a tab for the cover letter and a tab for their written statement. Ooh, but based on your explanation, there is no difference between both. CS Bonita, thank you very much for bringing this up. So if there is two separate tabs for the cover letter and the statement, then you're definitely going to be putting the written statement in the statement tab. So all the story that has to do, because if I remember correctly, you were referring to either refugee or the asylum application, written statement describing why you're applying for the asylum status, why you're claiming asylum. That's where it's going to be. The cover letter is going to be basically just as if you do have any, like I was mentioning earlier in this video, if you have any kind of unique situations and you want to bring something to the attention, let's say for example, it is highly recommended to apply, and that's just an example, it's highly recommended to apply for asylum within 6 months of entering the United States. Okay, so if for example you have been here in the United States for 9 months and you are just now applying for asylum, cover letter, that's where you're going to use the tab with the cover letter to explain why you're applying for that. So it's going to be separate. And then the actual why you're applying in the written statement, the whole statement, which will be like 3 pages, 4 pages long, describing the whole situation, you being persecuted, you coming to the United States of America, so far so forth, and why you cannot go back to the country where you came from. So yes, I was not aware of that, so thank you very much for bringing this up. If there are two separate tabs, one for cover letter, one for written statement, definitely the whole story, your whole asylum statement will be going to the written statement. And then if you have any brief notes basically for immigration, just imagine the immigration officer opening up your application package and something is, different, something you want to bring something to the attention of the immigration officer. This is where you're going to mention stuff, the cover letter tab. So again, yes, Bonito, thank you very much for bringing this up. Really appreciate it. Okay, let's move on to the next question comment from Sujan Kunwar 8643. I got documentarily qualified on February 14th. Since then, I didn't receive an interview date. Okay, so you have been documentarily qualified February 14th, so that is about 5 months ago. So it depends on which category you're in. If you're in one of the family preference categories and your priority date is not current yet, you might be waiting for the availability of the immigrant visa. If you're in the immediate relative category, or if you're a family preference category and your immigrant visa is definitely available, your priority date is definitely current, you're still fine, because again, I've seen cases where the interview after the immigrant visa was already available took about a year to schedule. It happens. It really depends on how busy the US Embassy is. So a few things that I would recommend you do, if you can, come back to this channel and submit a separate comment with your priority date. Please put your family preference category and also the chargeability area. I might be able to take a look at the visa bulletin and let you know if your immigrant visa is already available, if your priority date is current. And also, if you know for a fact that your immigrant visa is already current, you can reach out to the US Embassy in the country where you will be going through the interview and ask them, I want to, you can let them know, I just want to follow up. My immigrant visa should already be available because it's immediate relative category, or because my priority date is current on the visa bulletin. I just wanted to see when the interview was scheduled for, because if it is current, then most likely it was already scheduled. It's just they cannot send you the interview notice up until 30 days before the interview date, because you have to do your medical examination within 30 days. So if it is current, if your immigrant visa is already available, most likely it is already scheduled, and you should be getting your notice pretty soon now. But again, it might be the case that you're already documentarily qualified, but you're still waiting for the priority date to become current. And in that situation, if you can give me the 3 things: priority date, family preference category, and then the chargeability area, I might be able to give you a little bit more details. Okay, so let me post the answer here, and we're gonna move on to the next question comment from Shinuda Bekit 8701. Thank you for another comment, Shinuda. Appreciate it, and appreciate you being publicly subscribed. So he says, "Hi, it is me again. Yes, I meant the form I-730, but I totally get it now. Thanks. Another question: can I apply for a green card on my own, or do I have to ask a lawyer or a refugee community to help me? Is it hard? When can I file it, and how? My result as an asylee was on December 20th. Thank you so much." Okay, Shinuda, thank you very much for your questions. So yes, absolutely, you can apply for the green card yourself. You technically don't need a lawyer in order to do that. It's pretty straightforward. You use USCIS, you find the form, and I'm pretty sure it's form I-485. Let me see, 485. Application to register permanent residence or adjust status. There you go. I'm going to post that link into your comment so that you can go through it and familiarize yourself on how to do it. And I do have the video on step-by-step filling out this application. So you can definitely do it yourself. Of course, the help of the refugee, immigrant community in general is always good. It's always good to do your research, see similar cases, how long they took, what kind of problems there were, if there were any. It's not really that hard. It's not as hard as applying for asylum or a refugee, for sure. But to answer your last question is how long, when can you file it? 1 year. 1 year after having your granted refugee or granted asylee status. And it sounds like you are asylee and not refugee, because you do have your result as asylee. And asylee, if you have applied from within the United States, asylee. If you have applied outside of the United States, refugee. Sounds like you are asylee though. So if you got your asylum granted on December 20th, 2022, it means after December 20th, 2023, you can submit this form I-485 application to register permanent residence. So let me post my answer right here. Post the link for this right here. And if you have any questions along the way, you are always welcome to come back to this channel and ask them here. So let's move on to our very last question coming for today. Let's see. There we go. I'm going to read it. Oh, looks like a long one, so it's going to be an interesting one. It's from Creative Skull 9643. Hi there, you forgot to answer my question posted in volume 127, but here it goes again. Creative Skull, I'm very sorry I missed your comment. I can't say unfortunately, but I do get a lot of comments on this channel every single day. You see, just today, it's only 1 day old, so I didn't even get to the comments that were posted yesterday. So we'll see how I will be able to deal with all of the comments and the volume of the comments that are coming in on this channel. But if I missed it, sorry, and I apologize to everyone. If I missed your comment, just post it again on most recent video and I'll try to get it next day, in the next volume. Okay, so Creative Skull says, hello, I'm a US citizen. I sponsored my sister in 2007 and she lives in India. Her priority date is February 22, 2007. When I put in information to check status online in USCIS, it says the case was approved on January 22, 2008. Okay, so that's USCIS. And was sent to the NVC. Yes, this is definitely USCIS. My sister in India received mail from NVC in 2008. Okay, great. Acknowledgement with case number and priority date. I didn't get welcome letter from NVC yet. Is that normal? Okay, I think I tried checking case at NVC website, to which they require invoice ID, yes, too, along with a case number, which I didn't have. Okay, so that invoice ID, it should be in the email that was sent to your sister, which I didn't have. So I asked NVC about this invoice ID number through public forum, and they replied me today with 2 separate 8 digits invoice IDs, one for visa petition and a separate invoice ID for beneficiary, my sister. I tried logging into CIC as a petitioner with case number and invoice ID, to which it says, please be advised that the case that you have attempted to access is not eligible for further processing by the National Visa Center at this time. Please click on the contact the NVC hyperlink if you believe that you have received this message in error. Okay, so let's take a look at the visa bulletin and make sure that the NVC portal should already be fully open for your sister's case or not. So we're going to take a look at the visa bulletin. Graph B, because this is the graph, dates for filing. This is the graph that shows us which priority dates are becoming current for the NVC portal to be open. Not for the availability of the immigrant visa, but for the NVC portal to become open so that the beneficiary can start documentary qualification process. So right now, looks like F4 for all chargeability. This is we're not going to be looking at all chargeability because it's India. India have a separate chargeability area. So looks like for India is February 2006. So people, beneficiaries with the priority date in February 2006, as of right now, July 2023, they get their welcome letter from NVC, and their NVC portals are fully opening up to start documentary qualification process. And your sister's priority date is in 2007, February 2007. So looks like, okay, so it's February, it's exactly a year. So 2006 and year 2007. So there is 1 more year. So everything is good. Don't stress about nothing. There is 1 more year for the NVC portal to fully open up so that your sister can start her documentary qualification process. And then another year for the availability of the immigrant visa. So you guys are pretty close. You've been waiting for a very, very long time, and you are really, really close. Just 2 more years for your sister to immigrate, roughly. I would say 2.5 years, because I like to give some extra time, because backlog, it only keeps on growing. And then there is administrative processing with the interview being scheduled, all of that stuff. Obviously, there is also the process of becoming documentarily qualified. But 1 more year for the NVC portal to fully open up, where you can log in, fill out the DS-260, pay all the fees, submit all the civic documents, all of that stuff. I would definitely recommend checking out the video that I did on this channel on becoming documentarily qualified. It's called Documentarily Qualified, what does it entail? And in that video I show a real NVC portal that was already documentarily qualified, and there you can see which forms you will be filling out, which fees you will be paying, which documents you will be submitting. So if you can prepare as much as possible beforehand, that would be great. But everything is good in your situation. Don't worry about anything. I'm going to read the rest of the comment and address the rest of the questions. I'm confused. Why is it showing me this message? It's showing this message because the portal is still closed, because the priority date, it just didn't get to that point yet. It didn't become current. I tried as principal applicant too by filing in case number with my sister's beneficiary invoice ID, to which it says the information is not matching correct. Are there 2 different invoice ID numbers? One more for petitioner and one for beneficiary? No, there shouldn't be 2 separate ones. It should be the same exact. I don't know why they sent you both of those. I don't know why they sent you 2 invoice IDs. There should be 1 invoice and 1 case, and you're filling out that. So the one that worked, the one that gave you this message, please be advised that the case that you're blah blah blah, is the correct one. Just to let you know that I'm not documentarily qualified yet, as I never had invoice ID nor received any welcome letter. So it's not actually you who's going to be documentarily documentarily qualified. It's your sister, because you are already a U.S. citizen, but you will have a very important role in helping her becoming documentarily qualified, because you will be filling out the all the sponsorship information and all that sort of stuff. So absolutely, you need to be familiar with the process, and it's good that you're trying to stay on top of the case. That's really good, because a lot of people, after waiting for so long, they kind of forget it. Are there 2 different invoice numbers? So just what is the estimate time in general for NVC to send welcome letter with detailed info? In my case, it's been 15 years. The case from USCIS has been sent to NVC. Yes, that is correct, and I know it is ridiculous for someone to say, yeah, this is good, everything's correct. 15 years, it's not good, it's not fair. Unfortunately, this is the problem with legal immigration and family reunification in general. Because of the backlog, people are waiting for as long as you have been waiting for, and I can personally relate. So please don't get me wrong when I say, oh, everything is going good for you, because I have, I actually petitioned for my brother, and I have to wait another 13 years for his priority date to become current. So I can definitely relate to what you're going through. On the plus side, you guys did most of the waiting already, and it's literally just about 1 more year left for the NVC portal to open up. Familiarize yourself as much as possible with how to become documentarily qualified beforehand, so that once it's open, couple days, you submit everything, done, documentarily qualified, and then you guys are just waiting for the priority date to become current for immigrant visa, and then the immigrant visa interview. That's it. Another question is, when I applied for my sister, I filed her husband and 2 minor kids. Her ex-husband passed away, and now she's remarried. My question is, can her current husband can also come at the same time when she receives her immigrant visa? Yes. And what kind of visa will her husband get? So it's going to be derivative beneficiary of the beneficiary herself, which is your sister. Will he also be eligible for green card right away like my sister, or is there a wait? No, absolutely, it's going to be the same wait, because your sister been doing all the waiting for her family. So that's it. Plus, her husband has 2 unmarried kids of older than 21 years from his previous marriage. When can he sponsor them? Thanks, and sorry for a long question. Oh, not a problem at all. Sorry I didn't get to your original comment on time. So yes, he will have to petition for once he comes in here, once he gets his permanent residence. Immediately, once he gets his permanent residence, and it's going to be upon the entry, he can petition for his children. Yes, there will be some time involved because it's going to be F1 category because they're older than 21, and F1 for India looks like the wait time is about 6 years right now, as of right now at least. No, actually that's for graph B, never mind. So for the total availability of the immigrant visa, it looks like it's about 9 years for first preference category, and that's if they are unmarried. But on the plus side, he can definitely petition for his children upon getting the permanent residence. So let me pause this, and thank you everyone for all your comments and questions today. Always appreciate them. Again, if you have any follow-up questions, comments, just make sure to submit them in a separate comment. Don't reply to my comment because YouTube does not send me those notifications. As always, thank you very much for your time. Thank you for watching. God bless, and I'll see you all in the next video.